Welcome to our Law for Community Workers series, wrapping up what's new in the law in 2024. In this episode, Legal Aid New South Wales criminal lawyers Hayley and Helen talk about what's new in criminal law in New South Wales. Before we start, we would like to acknowledge the traditional custodians of the lands we are recording on today and pay our respects to elders past and present. Just a reminder that this podcast is general information only and cannot be relied on as legal advice. The information is correct at the time of publishing but may change. If you need help about a particular situation, contact our team at Law Access New South Wales via web chat through the Legal Aid New South Wales website or call 1300 888 529. Thanks, and let's get started.
Well, thank you. We're actually speaking today at the end of the year 2024, and it's been momentous. It's been a huge year in legislation in New South Wales. There's mainly been three pieces of legislation that have created significant change that relates to domestic violence. The first piece of legislation is the Crimes Legislation Amendment Coercive Control Act of 2022, but that came into force on the 1st of July this year. That piece of legislation, and we'll talk about that in a minute, deals with coercive control. They call the offence of coercive control domestic abuse or abuse of intimate or partners or former partners. The second piece of legislation that's made a bit of an impact is the Crimes, Personal and Domestic Violence Act, which put a new Section 6A definition in to include domestic abuse as a form of domestic violence. And the third piece of legislation that's created a significant change was an amendment to the Bail Act that now interacts with these new definitions of domestic abuse and how they have created new and different types of AVOs and then new and different types of breaches of ADVOs. And ADVOs are apprehended domestic and personal violence orders. So those three key pieces are what we're seeing as the major parts of change in this state. So Helen, you and I have done a few of these podcasts and a lot of community education this year. What are the main guts of the crimes legislation and amendment coercive control? What's the guts of it for community workers who might be listening today?
Well, it really criminalizes actions that were already known to be happening. It criminalizes patterns of behavior, which may add up to a very controlling relationship. So, violent and threatening behavior, behavior that causes the person to fear for their safety or the well being and safety of others, physical abuse, sexual abuse, financial abuse, verbal abuse, behavior that degrades or humiliates or shames a person, intimidation of a person, stalking, and that can include putting a GPS on a car, that sort of thing, harassing somebody, tracking their communications and movements, whether it's physically following somebody or electronically monitoring somebody, damage to property, and causing or threatening to cause death or injury to an animal, a beloved family pet, for example, or causing a pet or an animal to attack somebody as well, and preventing people from participating in their own culture, religion, that sort of thing, and isolating people from family and friends. All of these sorts of behaviors are recognized as behaviors which form a pattern of domestic abuse.
And that pattern is what is the big shift in this legislation, because before, what was known in the domestic violence space were incident offences. So common assault, damage property, stalk, intimidate, things that happened on a particular day at a particular time that involve certain acts. Whereas this legislation expanded the concept of what could be domestic violence to include lots of little things over a period of time that significantly impact a person's autonomy, a person's rights, and a person's safety within a relationship. So they've expanded it to that pattern of behaviour. And the other thing, Helen, is that it increased the penalty as well, didn't it?
That's right. So, an offence of this nature carries a 7-year maximum penalty, whereas some of those other offences, like common assault, which may be included in a pattern of behaviour as well, is a 2-year maximum penalty, or an assault occasioning actual bodily harm has a 5-year maximum penalty.
And that's really trying to explain to the community that as a community standard, this behaviour is considered to be particularly serious. And that comes as a result of data investigations over a long period of time working with victim survivors that showed that there were markers in the instances of domestic homicides where coercive control is basically a precursor to domestic homicide. So that's seen as an increased level of severity when this type of stuff is going on. If we look at how adding that definition to Section 6A in the Crimes, Domestic and Personal Violence legislation changed things, it opens the door to say that this behaviour is now it's an acceptable ingredient for applying for an ADVO. Is that right?
That's right.
So if we follow the thread there with the AVO legislation, they've changed that too, you see. So we now have some recent amendments that have just come out in, I think, October this year that allow for the offence of an aggravated breach of an ADVO and then also a persistent breach of an ADVO. Can you just tell us a little bit about those, please?
So the new aggravated breach of an ADVO with intent to cause harm or fear or knowledge such harm or fear is likely is punishable by up to 3 years imprisonment. So in the past, a breach would be 2 years maximum, and the new aggravated offence for persistent breach of ADVO, which is at least 3 breaches within a 28-day period, where a reasonable person will consider the breach as likely to cause harm or fear, is punishable by up to 5 years imprisonment.
And so you can see that there's this dial is just being turned up on domestic violence. Along with that legislation, there was also some civil provisions that were provided for a serious domestic abuse prevention order. They're there where a person's being asked to do positive acts of refraining from certain things. Can you explain that a little bit?
So police can seek conditions against certain offenders, yeah, including positive obligations.
It's kind of modeled on how they've put similar orders in people who've got, terrorism charges. They're not allowed to associate with certain groups or go to certain places. They might have to comply with certain types of monitoring and reporting in. And we already have similar legislation that relates to people who have a serious pattern of offending in terms of child offending or child sexual offending and antisocial groups such as bikie groups and terrorism groups. So it's modeled on that type of mechanism, isn't it?
It is, and also on those obligations, one obligation under the Bail Act, we're talking about also changes to the Bail Act, is that a person is not to be granted bail unless they can show cause for certain serious domestic violence offences, and they must be subjected to electronic monitoring. This is a huge change. Unless the bail authority, being the court, is satisfied that sufficient reasons exist not to impose electronic monitoring on the person.
Just very briefly about that, what show cause generally means is that there's something specifically very different that makes your case stand out.
And for domestic violence offences, the maximum penalty of the charge is something that's 14 years maximum penalty or more, for it to then invoke the requirement of electronic monitoring.
So we have offences that say sexual assault offences, they would come under that umbrella.
Yes,
Um, the kidnap detain offences, they come under there as well. So it's that really high level offending is considered to trigger the need to enter into show cause and the need to enter into electronic monitoring.
and it's show cause why your detention is not justified.
And that change came about as a result of sort of the community outcry from the death of the lady in Forbes at the hands of a person who was on bail. And the community was essentially saying, how can someone be given bail and then afforded no protection. And so the government, again, has taken on board community attitudes and has turned up the dial in providing measures with the aim of protecting victim survivors. And so now there's that default position that bail is ordinarily should not be granted, and you have to overcome that first hurdle. And then in addition to that, being granted bail must take into account the views of the victim and or their family and or the police, and also ordinarily must come along with electronic monitoring.
And the electronic monitoring is funded by corrective services,
Right.
which is the government. In the past, if people were to get bail with an electronic monitor, it would be the individual that would have to pay for that, for bail. Bail was very difficult for people without money to afford the cost of the electronic monitoring. It's thousands of dollars per month. Now it's something that the government would have to foot the bill for the electronic monitoring. But the whole idea is to be able to track the movements of somebody. So if they're going into a place, a location where there's an AVO in place saying they are not to approach 100 meters of the home, and they're there, then that, hopefully, if it's monitored in real time, would capture that breach.
I really hope that we're having this conversation in a year from now and that we see that that measure has had tangible statistical outputs. Because if measures like that had been in place for that lady in Forbes, you just wonder what would have happened. So perhaps we will be talking about this in a year from now. Well, that kind of is everything that I think we can offer in such a short time space. But I really hope it equips you with catching up with where we are going in New South Wales with domestic violence.
Absolutely. And we have some other expanded podcasts on this topic.
And a final shout out that we also, as Legal Aid, have a variety of services. We support people in family law, we support people in civil law, and we also have a special group called the DVU, the Domestic Violence Unit, who are specialists. So we are a one stop shop, but each of those different spaces doesn't necessarily interact with the other. We do things called firewalls, but we do have a large amount of areas for advice that you can come and see us about.
That's all for this episode. Thank you to Hayley and Helen. You can check out our other episodes in this series, wrapping up what's new in civil law and family law. We'll put the links to those and more in the show notes. Bye for now.